Today, the Supreme Court struck down race-conscious admissions policies. And I want to help you understand, what does that actually mean for you, especially if you are a student of color and you are applying to law school this cycle. Has that completely changed your admissions process? Should you change something about your application? What are schools going to do with this new ruling? Let's talk about it. For those of you who are new and don't know, my name is Montgomery, and I am the founder and executive director of Barrier Breakers, a faith-based 501c3 nonprofit that specializes in working with first-generation and minority students on their law school applications process. We are the parent company of the S. Montgomery Admissions Consulting brand, and we are so happy to be here today, or not happy to be here today, depending on how you look at it, to talk to you about the recent Supreme Court ruling. So what exactly happened? Well, today, the Supreme Court ruled in two different cases. The Supreme Court struck down what is colloquially called affirmative action, but is really race-conscious admission, and we'll talk about that at the University of North Carolina and at Harvard University. The plaintiffs in that case were Students for Fair Admission, and it was brought by a white man, seemingly on behalf of a group of Asians who were saying that the policies at the University of North Carolina, which is a public institution, and the policies at Harvard University, of course a private institution, unfairly discriminated against Asian American students in the admission process. Now, I want to first kind of parse out the difference between this broad landscape that we hear of affirmative action and race-conscious admission, because you'll probably be seeing both terms in the news, depending on the style of writing, and you might be like, are they the same? Are they different? What does it even mean? So affirmative action is a really broad term, and usually when people think about affirmative action, if you're not looking at the law, you're just like, what is affirmative action? People usually think of a group benefiting or getting or receiving benefits that will help them kind of affirmatively push them up in a process, usually because of the color of their skin. People will debate whether that's fair or not fair based on historical injustices, based on things that have happened in the past, racial disparities in education, even K-12 education. The history of discrimination in this country for education is very long. When you hear the term race-conscious admission, though, it's really a very small subset. And why is that? Well, it's because affirmative action has actually been litigated in the courts since at least 1978. And it's consistently been ruled that race can be one of many factors. But affirmative action has sort of been tailored and narrowed a little bit over the years throughout cases, and the case that is getting cited the most is the 2003 ruling Grutter v. Bollinger, in which the court said that race could be considered as a factor in the admission process because universities had a compelling interest in maintaining diverse campuses. And so the majority opinion of today's Supreme Court ruling is going to say, oh, we didn't really overturn it, but the concurrent opinion basically, yeah, it's more or less overturned. The goal of a race-conscious admissions policy is to increase student diversity in order to enhance the education experience of all students, right? There's countless studies and research that shows that students actually learn better in mixed environments, and of course students from lower socioeconomic or racial minorities actually have the highest boost when they go to highly selective schools because of the upward mobility that it provides. So it allows schools to employ recruitment programs and scholarship opportunities intended to boost diversity. And today's litigation was mostly focused on admissions. Now, I use race conscious because, like I said, it's been pretty narrowed down to the fact that the question before the court is whether or not race explicitly can be one of many factors, not the only factor, not the reason you've gotten into school, but one of many factors when it comes to admissions. If they can take race into consideration, if they can also take the racial makeup of their class into consideration, if they have a goal towards diversifying the class, maybe they only have 3% Black students and they'd really like to get to 5% Black students. The national population of Black students or Black people in this country is 13%. So, 3 to 5% is still woefully underrepresented, but a school might have had a real compelling interest in increasing the percentage of the Black students on their campus, of the Latino students, of the Native American students, right? Previously, before today's ruling, schools could take into consideration the racial makeup of their class as part of the admissions process. And they could explicitly look at race as one of many factors. And you might see that also in some of those diversity programs and fly-in programs and scholarships, all to increase the diversity of their class. So what does it mean that the Supreme Court today struck down quote-unquote affirmative action, or really struck down race-conscious admission policies? What it means is that schools can no longer look at the racial component of their class as part of what goes into their admissions decisions. Schools can no longer explicitly take into account a student's race as one of many factors in a holistic admissions process. Now, this is going to affect selective institutions significantly more than non-selective institutions when we're looking at the undergraduate level. So there's about 4,000 colleges in the US, and more than 75% of them take more than 75% of their students, and they will be just fine for the most part. But we are talking about really, there's a lot of really selective schools. You've been seeing that admissions on the undergraduate level, some schools have 2, 3, 4% admission rate. Like, those schools are the ones that are going to be the most affected by this policy, because they will have to come up with race neutral ways in order to increase diversity. Now, when you look at the law school application process, first off, there aren't that many law schools. There's less than 200 ABA accredited law schools in the country. And what everyone tells you, law school is competitive to get into at every level, right? And part of what they want to do is build a racially diverse class, because they are building the lawyers that are going to be making policies and arguing against the Supreme Court and making laws. And they have a compelling interest in creating a diverse class of law school students so that they can continue to create a diverse legal profession, to have lawyers that represent the makeup of this country. Currently, less than 5% of all lawyers are Black in a country with 13% of the population is Black, right? And so law schools have a commitment and a compelling interest in diversity and creating a diverse class. However, they also will not be able to take race into consideration in the admissions process, which also means people often say, oh, if you're an underrepresented minority and your LSAT score is such, you might be able to get a little bit of a bump. I'm not going to even go into the merits of that. What I will say is, whatever the merits of that is, it's no longer, right? Being an underrepresented minority on a racial factor is not something that they will be able to take into consideration as part of the admissions process. So that is kind of what happened. I have a lot of thoughts about this. Justice Roberts says in his opinion, he talks about the fact that universities have been going against the Constitution, because rather than taking in a student's hardships and the lessons that they've learned and the skills that they've acquired, they're using race instead as a proxy. And I feel that that is a complete hogwash, because we all know that students of color are often judged in every area, in hiring, in admissions, in every area by the color of their skin, sometimes irrespective of their accomplishments and what they've had to do and overcome and their hardships. We do not live in a race-blind, color-blind society. We live in a society where systemic oppression and systemic racism is in every facet of society, from where you go to school to what neighborhood you live into, how much funding your school has, the information resources, the wealth gap and disparity, right? There's statistical evidence about the wealth gap between races, about standardized testing, and what that really shows about wealth and privilege. There's a lot there, right? So we do not live in a colorblind society. And when you look at hiring practices, we certainly don't live in a colorblind society, where there's discrimination when it comes to getting certain firm jobs, to getting appointed as a judge on the bench, to moving up in the ranks, right? Like, we don't live in a colorblind society. Like, we just don't. So to say, oh, but admissions, should be colorblind because people need to be judged based on their skills. This is America. This is a meritocracy, is complete ignorance. It ignores the reality of what's actually happening in society. And you can see that in Judge Ketanji Brown Jackson's dissent, where, she says that basically the majority opinion is a let them eat cake obliviousness, right? That just because you're saying race doesn't matter in the law doesn't mean that race doesn't matter in society. There are disconnects between what's happening at the Supreme Court and the world that they would like to be in, right? The world in which everyone has a fair shot, doesn't matter your skin color, doesn't matter your background, it's just all equal. We're all the same, right? That's what they are trying to say. However, you go outside the Supreme Court, you just look around, you see society, and that's not reflective. And so when you think about your job as a lawyer, your job as a judge, and and the rule of law and the impact that that has on society, there's the letter of the law and there's the impact that that has on society. And unfortunately, we've seen from states that have already had these affirmative action bans like California and Michigan, what happens to Black and brown enrollment at schools where they aren't able to have a race-conscious policy. We see the impact of this decision isn't equality for all. The impact of this decision is a reduced enrollment in minority students at both the undergraduate and graduate levels. Because if you have a reduction in students at the undergraduate levels, you're going to have a reduction of students at the graduate levels. You're going to have a reduction of students or lawyers of color in the workforce, right? It's kind of A to B to C. There's the ruling and then there's the reality of that ruling. So what exactly does it mean that schools won't be able to take race into consideration? How are they going to continue to build a diverse class? They will have to look at other factors. And there have been a lot of think pieces and a lot of articles on how socioeconomics, family wealth, and income might play into that. Now, this is a little bit easier on the undergraduate level than on the graduate level because you can take certain things like neighborhood income, family income, when you're talking about socioeconomics into play when you're looking at undergraduate admission. When you're looking at graduate admission, people might be living everywhere or working everywhere, but it does not necessarily show the painting of their background. We will probably see more schools start to ask about first generation status. If you were the first person in your family to go to college, if you were the first person in your family to go to law school, and that's really important. Here at Barrier Breakers, we have always had an expanded definition of diversity. So we do support and have sliding scales for students of all marginalized backgrounds and also students who are just the first in their family to go to college or the first in their family to go to law school, no matter their race, and students that have socioeconomic need that are low income regardless of race, because we do understand that socioeconomics and being the first person, it is a barrier, it is a hardship. There's bonding there and there's support there that we want to provide. So I will also say that in a time like this, if you want to continue to support first gen students and minority students, there's a button or a link down below where you can donate. We are a 501c3 nonprofit, and the students that we support are students that we are able to support through donations and through grants, as well as being able to provide that sliding scale pricing. So schools are going to have to lean on socioeconomic factors. Now, there's a lot of talk too about essays and how important essays can be, because the Supreme Court was very careful in saying, we're not saying that students can't talk about race. You know, students can talk about race in their essays as part of what they've overcome. But you see how this is also going to start to put a barrier on students. What I don't want you to do, if you're listening to this and you're applying to law school in the fall, I don't want you to say, okay, I need to now pimp my trauma. I need to now talk about all of the racial disparities that's ever happened to me in my essay. That's how I'm going to get into law school. I don't want you to do that. The tenets of what makes a good law school personal statement and a good law school diversity statement, they are still applied. Now, if you're listening to this and you were thinking of only writing a personal statement and not a diversity statement, I would say now is the time to learn about diversity statements. We've got plenty of videos, plenty of resources for free, and also we're happy to help you through that. If you are someone that has a racial background that's important to you, there are definitely ways that you can weave it into your application. Because like I said, what makes a good personal statement and what makes a good diversity statement, what makes a strong law school application has not changed with this ruling. And you may need to also include more about your background and ethnicity in a way that is not just, here is all of my trauma, please use this as a reason to accept me, right? There is a way that you can go about crafting strong law school essays, an application. It's not just even your essays, there's letters of recommendation. There are ways in which you can talk about your diversity, your racial diversity, your religious diversity, your sexual diversity, your gender diversity, your socioeconomic diversity, your family upbringing, your geographic diversity, your political diversity. There are ways that you can do that in either your personal statement or your diversity statement, depending on why you want to go to law school, depending on the reasons that are bringing you there in your why law statement. That is not seen as simply, oh, she's just telling us this because the Supreme Court said we can't take race into consideration and she just thought that she would throw in a paragraph about what it means to be Black in America. Please don't do that. Law schools are are still continually committed to increasing diversity. I think that's something that you really need to know. Hear me when I say that law school admission deans are still committed to increasing the diversity. They are going to have to do it in a way that follows the law. They are not going to run afoul of the ruling of the Supreme Court. However, they are still committed to increasing diversity. So there are ways that you can help yourself, help them, help you in this process, even with this ruling. And we're gonna have videos and we're gonna have guidance on how you can use your essays, how you can use the other parts of your application to help bring about your full story and to help also share your racial background given the Supreme Court ruling. So we will have videos and guidance on that. If you're not already subscribed to our YouTube channel, if you're not already following us on Instagram, if you're not already subscribed to our podcast, now is the time. If you have a friend or two, whether they are Black, brown, and Native American, Asian, what have you, white, they're just questioning, tell them, tell a friend. We will also be discussing this at our Break Into Law conference, our free virtual conference that's taking place next weekend, July 8th and 9th. You can register at bit.ly/break-into-law. We'll put the link below. There's an entire panel there on the future of legal education, affirmative action, AI, and beyond. There's also a panel on equity and law school admissions. So there are some panels that will talk about this. We also have law schools. We have over 40 law schools at our law school fair on Saturday. Ask them these questions, bring them your concerns, talk to them. If you're in law school, talk to our law firms. We have about 20 different law firms and public interest organizations, hiring and recruitment managers. Ask them about diversity and hiring practices and what they think. Like, this is your opportunity to get some of these questions answered just next weekend, right? You don't even have to wait. So if you're concerned about what to do, the new ruling, and you want to talk to a law school about it, next weekend is your opportunity. You can register for free, it's virtual, and everyone that attends will also be entered to win up to $3,000 in scholarships for your law school applications or your law school tuition. Our partners at 7 Sage are giving away LSAT prep courses. We have bar prep courses that we're giving away from our partners. And so there's lots of different goodies for you, but this is also your opportunity. If you're stressed about this, if you have concerns, if you don't know where to go to the Break Into Law conference next weekend, July 8th and 9th, and get your questions answered. So to put it plainly, if you are applying to law school this cycle, what does this mean for you? How can you deal with this? It means that you need to be very intentional in your essays. I have always said that your essays are very important. I have always said that. And people consistently are like, oh, the only thing that matters is my LSAT and GPA, LSAT and GPA. Right? Your essays matter, and your essays matter so much more now with this Supreme Court ruling, because you will need to be able to tell your story. It is also important, so that if you are a student of color, that you are best preparing yourself for the law school application process, that you are applying early. If you think that you are going to be someone that is applying under the medians, whether your GPA is going to be below the median or your LSAT score is going to be below the median, you need to apply this fall. You don't have to apply in September, October, November, perfectly fine months. Do not apply in February and March. Not this year. This is not the year to do it. Actually, it probably won't ever again be the year to do it. It never was the year to apply in February and March. But you are entering a new paradigm in which you will not have any of those race-conscious policies. And so you want to make sure that you are the best prepared applicant that you can be. You always want to make sure that you're the best prepared applicant that you can be, regardless of your race, regardless of the Supreme Court ruling. And so the things that we have been saying for the last 2-3 years, they're still here. You want to make sure that you are investing in yourself, investing in test prep resources. If you don't have money for test prep resources, there are programs that have free test prep resources. I just told you we are giving away free test prep courses for the LSAT at our Break Into Law conference. We are also looking at different ways that we can supplement test prep courses for students that work with us, and those are things that we'll be continuing to develop in the next coming months so that you can be best prepared. That's going to be very important. You want to make sure that you have strong letters of recommendation, that your resume looks good and professional, that you've researched schools, that you've gotten to know admissions. This is the best thing that you can do for yourself. If you are a student of color, get to know the admissions officers, get to know them, have them know you in a respectful way. Go to conferences, go to forums. Some of them have Zoom open office hours. Get to know them and help them see your story and know who you are as a person. And make sure that you are crafting the strongest essays you possibly can. Personal statements, diversity statements, any supplemental questions, all of those are so much more important now. That is the advice that I have to give you if you are a student of color and you're wondering, how does this change my application cycle? A lot of it is the same stuff that we have been saying, but it is just so much more important that you hear me now and hear me say it. You need to be on your A game. You always needed to be on your A game, but you really should take this opportunity to say, am I doing everything that I can this summer to prepare to have the strongest law school applications this fall? And if you're not, can I wait another year and take this time to prepare my LSAT score, to prepare my essays? How do I not rush this process so that I don't miss out on a great opportunity to go to a great school? How can I talk to admissions so that they can get to know me as a person? These are all the questions that I want you asking yourself. Now, the last thing I will talk about is, there are questions about what is this going to do for law firms. This ruling was very specifically about admissions, but I anticipate it will have a chilling effect on some of these diversity programs, diversity 1L programs and fly-in programs that firms have, and they will also have to get creative in order to avoid, potentially being sued. Nobody really wants to be sued, not even lawyers. Lawyers don't want to be sued either. Sure, we know what to do, but we don't want to be sued. Nobody wants to be sued. We're gonna have to watch and see what happens, but it is also important that you're taking advantage of opportunities to meet with law firms and to meet with people and to network. They say it's so cliched, your network is your net worth, but that could not be more important. So please definitely take advantage of opportunities. Like I said, next weekend we have our Break Into Law conference. You can meet with law firms, you can meet with public interest organizations. We're going to be developing programs for the second year 2L and 3L students that work with us to have opportunities to meet with firms and our partners. So we as an organization are doing what we can to continue to make sure that fantastic students, regardless of their color, regardless of their ethnic background, regardless of their socioeconomic status, are able to get in front of top schools, are able to get in front of top firms, are able to have that kind of upward mobility, because it's so important in my life. I come from a lower income background. Both my parents were in the military. My mom's a Jamaican immigrant. Going to Princeton changed my life. Going to Harvard Law School changed my life. And I know the power of upward mobility, and that is why we do this, because there should be so many more students who have that opportunity, because everyone deserves a chance, even if we all know we don't start at the same place. We don't have the same starting line, but that doesn't mean we all can't cross the finish line. If you have any questions, if you're concerned, if you're stressed, let us know. Reach out to us. We are here for you. We hope to see you next weekend at our Break Into Law conference. If you want to support us, the link to donate is below. Like I said, we are a 501c3 nonprofit, and now is the time. There has never been a more important time for this work, and there has never been a more important time to support students.